So I just want to say good morning here on Hafaday and good morning here on Guam, aloha and good afternoon in Hawaii, and welcome to our training for the Fair Housing Act hosted by the U.S. Department of Housing and Urban Development Honolulu office and support. And on behalf of the Chamorro Land Trust Commission, I would like to say thank you. Undunkalu Nesidus Maasi. I wanted to call on our chairman, Mr. John Regis Jr., just to say a few words before we begin today's training. Okay, thank you very much. Mr. Chairman.
Hi. Yes, good morning, everybody. Thank you so much, Ms. Carrie-Ann and Mr. Jelani for your help with us with this training. And thank you again to the staff for making themselves available and our commission members who are with us this morning. I'm looking forward to this. I'm sure it'll be a very informational and fruitful training. And, you know, again, it will help us to make sure that we are in compliance with the settlement. So definitely appreciate your guys' time.
Thank you.
Thank you so much, Mr. Chairman. Okay, so just a couple of announcements before we begin the training. Okay, and I'm pretty sure it's going to be reviewed in the training PowerPoint. But if you have any issues, if you drop off, if there's latency, just try your very best to log out and log back on as soon as possible, so that the training will continue. The second thing is it's very important to have your video on at all times during the training. Okay, so Commissioner Duenas, I'm sorry if we could ask you also to activate your video just for the purposes of there. Thank you so much for the US HUD folks, right, to make sure that they have everyone in their view screen. Okay. Also, from what I understand, the agenda will be outlined. Okay, so with regards to today, and then there will be an evaluation that will be distributed. It will be sent to you via email at the end of the training, so that you can fill it out and then send it back to Ms. Therese and Mr. Joey and CC myself, so that we can collect all of the evaluations and provide it to Ms. Carrie-Ann and Mr. Jelani for their professional development. Okay. Okay. So I hope I didn't miss anything, and I'll hand it over to our folks. I would like to introduce Ms. Carrie-Ann Shirota from the U.S. Department of Housing and Urban Development Honolulu Field Office, as well as Mr. Jelani Madraka, who will be joining us today. And also we have Ms. Rebecca Borja from the U.S. HUD, and also Ms. Catherine Taitano joining us. Thank you and welcome.
Thank you. Okay, Jelani.
Aloha, Hafaday, and aloha from downtown Honolulu, Hawaii, to you all out there in internet land. I guess we can go to the next slide, Jack, please. Okay, so here's the overview, our agenda for our time together. We're going to do the welcome first, and then the bulk of our time today will be an overview, general overview of the fair housing law. We'll take a break, and then we'll go over the law generally again, and we'll watch shows, and then we'll have a wrap up. And you know, this agenda is flexible. Those were just some estimated times, and you know, we're running a little behind now, but we'll make it up. Next slide, please, Jack. Okay, so these are some guidelines that we set up that help us to present this training virtually. So I think everyone seems to be muted and your camera is on. If you have any questions or volunteering any answers, you can raise your hand, and then, you know, we can call on you that way. Also, we can mute you, but you have to unmute yourself And when the training is completed, we have to verify everyone's compliance. And that's the reason why we ask that you keep your videos on, and in addition to allowing us to see your lovely faces. Next slide, please. Okay, so here we go. Carrie Ann, you first.
Okay. Hello, everyone. I'm Carrie Ann Hirota. I'm an equal opportunity specialist with HUD's Fair Housing Office in Honolulu. I'm relatively new to the HUD office, but previous to working with HUD, I worked for the Hawaii Civil Rights Commission, which is our fair housing partner in Hawaii, as an attorney and enforcement attorney. So I am familiar with fair housing laws, and I look forward to joining all of you today. Jelani?
Yes. So again, my name is Jelani Madaraka. I'm the lead civil rights analyst for the Department of Housing and Urban Development in the Honolulu field office. That's my contact information. So if you all have any questions, comments, want to get a hold of me after the training, feel free to do so. And that's the email address and our HUD website. I forgot to say that I think this month is Chamorro Heritage Month. And it was back in 2003. That was my first visit to Guam, and it was in March of all months. And I remember that Kathy and her, the crew, the people at Gura, they put on a big, wonderful spread. So we feel somewhat deprived because this training was supposed to be in person, and we would have loved to be there in person, especially during this time of year. But due to the pandemic, we have to do it in this way.
Yes.
Next slide.
And if I could just add also to participation guidelines, we really encourage you when we have moments for question and answers to engage with us, ask your questions. We learn from one another. You also can ask a question to the chat function. We are monitoring it, and we will do our best to answer each of your questions, whether it comes from the chat box or if you're raising your hand. Thank you.
Okay, so a bit about, go ahead, Carrie Ann, you can go.
So this is the mission of our Fair Housing Office. It's to eliminate housing discrimination, promote equal opportunity, and achieve diverse, inclusive communities by leading the nation in the enforcement, administration, development, and public understanding of federal fair housing and civil rights policies and laws. And that is our overarching mission and the work that we do. Next slide, please.
Okay, so let's break it down a little further. FHEO, Fair Housing and Equal Opportunity. Here are some of the activities we engage in, as we are doing today. Education and outreach. Our goal of education and outreach is to make sure that people understand what the law is, how it's interpreted, and how it applies to situations that arise in the residential real estate market. And so we try to solicit people's voluntary cooperation. We do that in a number of ways, by providing technical assistance. And we are the premier federal agency that we investigate fair housing complaints. So people file complaints with us. We conduct compliance reviews of those who receive money from HUD to ensure that they are complying with their civil rights related program responsibilities. We have 2 fair housing grants, one where we fund private organizations to assist in representing people when they believe that their fair housing civil rights have been violated, and another grant program where we provide money to state and local governments to enforce laws which are deemed substantially similar to the federal law. Again, we're trying to ensure civil rights compliance in all programs and activities that HUD has. And that's really part of the housing act, as we'll see as we go along today. Next slide, please. We have joining us today, as Jack mentioned, Rebecca. She is the Senior Community Planning and Development Representative. And she is from Guam, and she used to work for Gora. And she is another resource, wealth of information. That's her contact information. She might be being a little shy today. Rebecca, you want to say anything?
Thanks, Jelani, for the introduction. So, my name is Rebecca Borja. I used to live on Guam. I am from Guam. I worked for GORA for about 9 years before coming to work for HUD. I've been at HUD for about 15 years now, going on 16, in the Office of Community Planning and Development. If you're not familiar with that, it's separate from FHEO, but we work in partnership with Jelani and Carrie Ann. Our office's responsibility is overseeing the community development block grants, the home grants, emergency solutions grants, and continuum of care grants that Guam receives. And so the reason I'm participating in this training is I am the senior CPD representative that's assigned to oversee the formula and competitive grants that Guam oversees, in particular GORA.
Thank you, Rebecca. Next slide, please, Jack. And here we have the contact information for Kathy Taitano. She serves as the Fair Housing Coordinator. She's the Chief Planner for GORA. That's her contact information. Another wealth of information and a wonderful resource. Kathy has put on some trainings, fair housing trainings with myself in Guam a number of times. And Kathy, you want to say anything?
I can, thanks, Jelani. I can pick up from Rebecca there. I work for GORA now. I've been there for the 15 or 16 years since her departure. Our connection is that my division, the division I oversee as chief planner, is the administration. It does the direct administration of the community planning and development funds that flow into Guam, and it does. As a collateral duty, I am the designated fair housing coordinator for GORA for Guam, and I'm sure that these guys will take you through what my role would be as far as communication and contact for issues that you guys might encounter in your work through the land trust, and I'm here to help as need be.
Thank you, Kathy. Thank you.
Welcome.
Next slide, Jack, please. Okay, and as Jack mentioned, one of the principal reasons why we're joined here together is to, and as John mentioned also, is to fulfill the terms of the settlement agreement, but which requires housing training. But beyond that, we do education and outreach. Because as I mentioned, we try to let all of those who are somewhat involved in residential real estate to know what the law is, how it's interpreted, and how it may apply to the situations that you face on a day-to-day basis. And we do that to try to get your voluntary cooperation by letting you know what the law is. Next slide, please. Okay, so when we were doing preparation, one of the things that we talked about, Jack, I, and Carrie Ann, was that, after we complete the training today, and I guess it will be Tuesday in Guam, so in Thursday, then you have to, as a part of the settlement agreement, you have to sign this certification that you certify that you attended the training, that you understood the training, that any questions that you had concerning the training were answered. So get your questions answered, and that you understand how the federal law that prohibits discrimination on the basis of race and national origin, how it applies to your duties for the Chamorro Land Trust Commission. So we want to make sure that we help. So when you sign that certification, you can do it in good faith and honesty, and know that you know what fair housing is all about. Next slide. Okay, so now we begin our journey together. So we're going to be giving you the majority of our meeting today, an overview of the fair housing laws. And this slide gives you the citation for the federal law, the for the regulations. So if there's something that you do have a question, you can always refer to those sites, because the federal regulations, they elaborate on the law and really say how or indicate how HUD goes about to enforce the law, interpret the law, and apply it. Next slide, please. So this slide is a pictorial history of how we arrived at fair housing. Usually, laws come into existence because there was some need that was prevalent at the time that gave rise to those laws. So this slide has some pictures that represents the state of the land, so to speak, prior to the 1960s, prior to the passage of the civil rights laws in housing and education and public accommodations and employment. And we use this to kind of reflect back historically, and then it helps to show our journey forward, and we'll bring you up to speed of the current state of the law and how it applies to situations. One of these slides originates from Hawaii. Ironically, it's the top middle slide that says we serve whites only, no Spanish or Mexicans. And I guess that's kind of appropriate to our focus on race and national origin. Next slide. So we cannot talk about fair housing and civil rights without talking about the legacy of Dr. Martin Luther King. A lot of people may not be aware of the fact that during the last year of his life with us, he focused heavily on, integrating segregated housing. He focused heavily on fair housing, and unfortunately, tragically, it was a week after his assassination that the Fair Housing Act was passed. And next slide. Well, and I think we're going to show a little video that captures, that time period, the hours that led up to the passage, or the week that led up to the passage of the Fair Housing Act. Short video.
I just want to ask if, again, I can get that thumbs up. Can everyone see the YouTube video in their screen? Okay, great. And we're gonna, this is the 7 days documentary video, okay?
Few in the nation believe that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip. We got some difficult days ahead. A long night longevity has its place. I'm not concerned about that now. I see the promised land. I may not get there, but I'm out to the northern land. I see we get to the promised land.
Ladies and gentlemen, Martin Luther King was shot and was killed tonight in Memphis.
The death of the prophet of nonviolence set off the worst outbreak of arson, looting, and criminal activity in the nation's history. Washington's ghettos burned within a few blocks of the nation's capital.
The life of a man who symbolized the freedom and faith of America has been taken. And no words of mine can fill the void of the eloquent voice that has been stilled. But this I do believe deep. The dream of Dr. Martin Luther King Jr. has not died with him.
President Johnson was willing to speak up and say, we have to pass a fair housing bill.
District, we're in trouble. We need some help. Okay? I'm afraid of that.
Federal troops, for the first time since the Civil War, took up positions to guard government buildings.
Nothing's probably touchier than your own neighborhood and your own home or your own apartment. The administration, which supported the bill, said this has no chance. The other stuff is okay. If this will kill any politician that touches it.
Well, I just could not live inside them. I don't feel that they should be oppressed, but I moved here because it was a white community. I have 2 daughters and 2 sons, and if there's too many colored people around here, I definitely will get out. I think that the property values will immediately go down if they're allowed to move in here in a hamper.
It seems as though our country is pulling apart into separate societies, where whites have jobs and Negroes have unemployment, where the middle class lives in suburbs and the poor are left in the ghettos, where one group of Americans looks upon another group of Americans with growing mistrust and even dread.
Then the bill went over into the House Rules Committee, and under the chairmanship of the famous Judge Smith, a right-wing segregationist from Virginia, he would hold hearings on it. He would even take the bill home so nobody could act on it. And we were running out of time.
Thousands flowed through the rainy streets of Memphis this day, finishing a march that Dr. King planned to lead in support of striking garbage workers.
How many men must die before we can really have a free and true and peaceful society? Put your back alone. And I know you're rich out there. Take mine. You take mine.
The death of Martin Luther King is a tragic thing, but no legislation should be passed as a memorial to anyone. In spite of the riots, I'm going to support this legislation with all the vigor that I possess. The laws that we pass up here are but all sure. Martin Luther King come and go.
The public reaction to this horror gave the sensible members of the committee a compelling argument that the House Rules Committee had to report that bill on. And I think that's how it got a bill. They just didn't dare bottle it up any longer.
I have a dream that one day Negroes will be able to buy a house anywhere that their money will carry them.
Fair housing for all is now a part of the American way of life. Democracy's work is being done, and the Bill of Freedom brings out a little route. We have come some of the way, not near all.
Life still goes on because we unfortunately have the laws, but we don't have the enforcement. And we have changed, but we still have the same kinds of discrimination.
The U.S. Commission on Civil Rights said today that efforts by federal agencies to end housing discrimination have been generally superficial or incomplete.
President Carter has ordered federal agencies to use all means possible to strengthen fair housing programs. For the first time, people with disabilities and families with children will be protected from housing discrimination. President Reagan signed legislation today designed to toughen up the nation's fair housing laws. Why did you take part in this demonstration today? Just because there was a huge crowd, or did you have any personal reason?
Well, I took part in march today because of Martin Luther King and what he stood for. Because this march is what he died for.
You know what he stood for?
Yes. He stood for nonviolence and peace for all men from all countries. And I think if he died for it, I could carry out what he started.
You know what I'm saying? Man, you know, Martin Luther King stood for nonviolence. That was Martin Luther King. A street. And I don't give a fuck where you are in America. If you're a Martin Luther King,
Sorry.
it's a violence going down.
Okay.
That, of course, is Chris Rock's famous joke about.
Sorry.
That's
That wasn't
okay.
part of the, I think that's the next one.
Yeah.
Okay.
Okay, so we've reflected back. Now we're going to move forward. So the federal fair housing laws in 1960, the week after the assassination of Dr. Martin Luther King, Civil Rights Act, 1968, also known as Title VIII, was passed. And the law was amended a number of times. If you remember in the video, there was Dorothy Height, the civil rights leader. She talked about how the law wasn't enough back in 68 because it didn't have any enforcement provisions. So it wasn't until when the law was amended in 1988 that it included enforcement provisions. So now HUD, along with the Department of Justice, are the two agencies that administratively enforce the Fair Housing Act. And that didn't occur, that didn't happen until 1988. Next slide, please.
So the federal law, Fair Housing Act, also known as Title VIII, is very broad in its reach. It is considered a remedial statute. It's intended to remedy discrimination based upon various protected bases. So overall, the big picture is that the Fair Housing Act protects people from discrimination when they're renting or buying a home, whether they're getting a mortgage, they're seeking housing assistance, or they're engaging in any other type of housing-related activities. Again, the statute is meant to be broadly interpreted to have a far reach to remedy discrimination in housing. Next slide, please. So what's prohibited under our federal fair housing laws? These are, again, you're going to hear some of the information we shared today repeated throughout the presentation to just, again, affirm these different areas. Some of the examples, if where a housing provider refuses to rent, sell, deal with, or to represent that a housing is unavailable. Housing discrimination can take the form of differential terms or conditions, that you're maybe treating tenants based upon a protected class differently compared to other groups. Fair housing violation could include where someone is making a discriminatory statement while engaging in a real estate or a fair housing transaction, falsely representing that a home or rental is no longer available. There can be discrimination in terms of mortgage lending, harassment, where a person is subjected to harassment upon the different protected basis. There can also be discrimination if there's a denial of reasonable accommodation or modification where a person has a disability. And another area of violation could be where somebody is subjected to retaliation. The language used in the statute says coercion, intimidation, interference, as well as retaliation, statute and regulation. So you can see it's very, very broad for the reach to remedy housing discrimination. Next slide, please. So this is a slide, we're going to spend a few slides just to talk about our process within HUD. HUD, again, takes in complaints. People can either call in to our agency or they can submit inquiries online based upon a person's allegations or belief that they may be discriminated against. If we determine that there's jurisdiction over the complaint, then the case will be transferred to our enforcement division. Investigators will be assigned where we conduct objective fact-finding. We are not an advocate for the complainant, the persons who filed the complaint, nor are we an advocate on behalf of the respondent who the complaint is filed against. Our job is to gather in data, records, witnesses from all parties that it be an impartial investigation. Simultaneously, while we're conducting this objective fact-finding as part of our process, we are mandated to engage in conciliation. The belief behind this is that if we can bring the parties together and reach an agreement, even before all of the facts are gathered, that typically tends to work out best for all of the parties. So we do that simultaneously. If the parties are not able to reach an agreement, there is a determination made within our agency whether or not, based upon the information gathered, where there's enough evidence to support a finding or a reasonable cause determination that a violation occurred, or the opposite, that there was not enough information or evidence to support a reasonable cause finding. And Jelani is going to talk a little bit more about our process in the next slide. Next slide, please. Thank you.
Okay, so this slide talks about, the way that HUD goes about to enforce the law. As I've mentioned earlier, that it wasn't until when the law was amended in 1988 that it included enforcement provisions so that the law could be administratively enforced. Prior to that time, HUD just served as a mediator between parties when there were allegations of housing discrimination. And that's what we call conciliation. That aspect of the law is still a part of the Fair Housing Act. And so as Carrie Ann mentioned in the prior slide, we are obligated by law and statute to assist the parties to try to mediate, settle, resolve complaints of housing discrimination. But then we take in complaints, determine that we have jurisdiction or the legal authority to investigate those complaints, and make determinations of whether or not the law is violated. If there's a determination that, the evidence doesn't show any violation of law, then HUD will dismiss that complaint. And then the complaining party can take it up on their own, go into state or federal court. However, if HUD's investigation finds that there is enough evidence to support the allegations that there potentially could be a violation or there is a violation of the law, then that case will be set for trial or hearing before an administrative law judge. As I mentioned earlier, we try to get parties to voluntarily comply with the law, and we do that in a number of different ways. We do compliance reviews of recipients of federal funds from HUD to ensure that they are meeting their fair housing and civil rights responsibilities. But also we do that by issuing policy guidance and technical assistance. I always like to point out some of the guidance that we have. You can find it online, something good, helpful information that we, HUD and the Department of Justice has put together that, answers people's questions in a Q&A format that lets people know of how the law actually applies to situations involving like persons with disabilities, land use issues, a whole host of different things. And in addition to that, we work along with state and local agencies, other federal agencies to enforce the law. One of the provisions of the law requires that the HUD secretary ensure in all its programs and activities that it's in compliance with the law. So we do that with those that receive our money, but also we have agreements with other federal agencies such as like the rural development, the U.S. Department of Agriculture, Rural Development. We have cooperative understandings with them because, there are a number of different federal agencies that may be involved in some form or fashion with residential real estate. And so we have memorandums of understanding and agreement with those agencies to have a comprehensive approach to ensuring that the law is being followed. Next slide, please. Okay, so one of the things that we need to know about the law is that there are some requirements for filing complaints with HUD and in the courts. So this slide tells us that if someone wanted to file a complaint administratively with the Department of Housing and Urban Development, they would have to file their complaint with us a year or 365 days from the date of the last alleged housing violation. Someone can also file a complaint with the Department of Justice, and in that case, it would have to be within 18 months from the alleged housing violation. The Department of Justice, as I mentioned earlier, enforces the law with HUD, but their enforcement is a little different than ours. We deal with individual complaints. The Department of Justice deals with what we call patterns or practices of discrimination, or when there are situations involving issues of general public importance. They also get involved in the enforcement of the Fair Housing Act when there are zoning and land use issues, as well as when there are housing discrimination issues that involve some threat of force or some type of violence. Finally, an individual does not have to come to the Department of Justice or HUD to file a complaint. They can go directly into state or federal court and file a fair housing complaint or case. Next slide.
Okay, so I just want to add on to what Jelani was saying. You saw the past slide that somebody can simultaneously file administratively with HUD, but they could also pursue an action in court at the same time. But how do our fair housing laws work? So typically what happens, a person is a member of a protected class. And I know that that term may not necessarily, we're not sure what that means. We're going to talk a little bit more very soon about what a protected class is. But if a person is a member of a protected class and they believe that discrimination occurred because of their membership in that class, and that the person accused of the discrimination are not exempt from the federal or state fair housing laws, then that person could file a complaint with our office administratively. Next slide, please. So these are the protected classes under the federal fair housing laws. So there are 7. So throughout the presentation, you'll hear us talk about protected classes. Sometimes people use the term protected bases or even protected groups, but this is essentially the classes, groups, bases that we're referring to. The 7 are race, color, religion, national origin, sex, which has been interpreted to include sexual stereotypes and gender identity expression, also sexual orientation, disability. Under the statute, if you were to look at the language itself, it uses the term handicap, but we typically in training use the term disability because that is considered the better practice. But so if you look at the statute, it uses the term handicap. And we're going to get into these definitions into more detail. And familial status, which can include children under the age of 18, if an individual is pregnant, or if they are going to be adopting a child, if there's in the process of obtaining custody or guardianship. So under the federal fair housing law, there are 7 protected bases, and some states or other jurisdictions, they can enact and pass laws where they protect the 7 bases, and in addition to that, protect other classes as well. But under the federal law, this is considered the minimum, the floor that all of the jurisdictions need to at least comply with our fair housing laws, these 7 protected bases. Jelani, did you want to add anything more about this slide?
No, not at this time.
Okay. Next slide, please.
Okay, so one of the areas that we're going to focus in on, probably more so on, not today, on Thursday, we're going to talk about race, which is probably one of the, historically, that's one of the main reasons, or how the law, the Fair Housing Act, and other civil rights laws came into place. And so race refers to whether a person belongs to one or a mixture of these categories that are given to us by the US Census. So you have American or Native American or Indian or Alaska Native, Asian, Black or African American, multiracial, Native Hawaiian, or other Pacific Islander, and white. Those are the 6 categories of race. Oftentimes we find that, when people talk about race, they think it's just color. They say, well, it's a black or white issue, but no, race under the fair housing law means these 6 categories. And you know what I was going to say, in preparation for today's training, I looked back over the last 10 years to see what kind of cases and complaints we have seen originate in Guam. So over the last 10 years, there have been 6 cases that we have investigated in Guam, and 3 of those, half of those, were based upon race. One was based upon national origin, another one was based upon color, and another one was based upon disability. Next slide, please. So color, I just mentioned, we had one case involving color. So color, where sometimes people use it interchangeably with race, but it's really its own distinct category, and it means the color of one's skin or one's pigmentation. Next slide.
So religion is a protected class, and whether a person identifies with any particular religion or not, if somebody even is considered atheist or does not have any particular religious affiliation, Christianity, Muslim, Buddhist, that individual or individuals would be protected classes. And I want to point out that we have these different 7 categories, but all of us who are participating today may belong into protected classes on one or more bases. So sometimes you will see complaints where somebody files perhaps in alleging discrimination on the basis of race as well as religion, or race and sex. And we're going to spend more time about that terminology, intersectionality. Next slide, please. So the Fair Housing Act also protects national origin, and under the Fair Housing Act, Title 8, national origin, again, is broadly construed and includes ancestry. It can include birthplace, culture, ethnicity, as well as language. So in some situations, a person may allege discrimination on the basis of language because they have a particular accent, or maybe because were born in another country, their ethnicity. This would fall under the protected class of national origin. And we're going to spend more time tomorrow showing again sort of the blend of cases where you may have race as well as national origin alleged as violations. Next slide, please.
Okay, sex. So this gives us a little more on what the law means by sex. So under the federal law, it's the state of being male or female and the conditions associated therewith. So anything related to your gender, it's interpreted to mean gender, like one's gender identity or the expression of their gender or their identity in that form or that fashion. But it also includes sexual orientation. And so here on the slide gives us a citation of this Supreme Court case, Bostock versus Clayton County, where the Supreme Court has interpreted the civil rights laws to, under the protected area of sex, to include gender identity or expression and sexual orientation. And mentioned previously, it also includes stereotypes. And sometimes we tell the story in trainings of one of the first cases that came under the protected category of sex. You would think it would be against a woman, but it wasn't. It was a group of males who filed a complaint because the landlord did not want to rent to them because they were men, and that landlord felt like, well, men were more messier than women, and so that's the reason why he preferred to rent to women. So that's an example of a stereotype. And we should have mentioned that, I think in one slide, a few slides earlier, sex or gender was added to the original Fair Housing Act back in 1974. Next slide, please. Okay, so after the law was amended in 1974, then there was major amendments in 1988. And when the law was amended in 1988, one of the main areas that's now included is disability. So disability can be defined in a number of different ways. So this slide tells us that disability is a physical or a mental impairment that substantially limits one or more of a person's major life activities. What are major life activities? Walking, talking, breathing, hearing, seeing, learning, taking care of oneself. Those are major life activities. And so if there's an impairment of one of those, then that's one way that someone can have protection on the basis of disability. But also, if someone is regarded as having such an impairment, a mental or physical impairment, they could have protection on the basis of disability under the Fair Housing Act. In addition to that, if there's a record, if somebody has a record of having an impairment and they're treated differently because of that record, then that would entitle them to protection under the Fair Housing Act in the protected category of disability. Next slide, please.
And so our last protected basis is familial status, and the statute.
I think you muted yourself, but familiar status includes all of these things on this slide. It really means the presence of children. So, children under the age of 18 can be present in a household, a residential real estate transaction or related transaction if, it's their actual parents or somebody that's legal custody of them, or they're in the process of obtaining legal custody, or if someone is designated as the parent or legal guardian or has custody and then they're in the household. But under familiar status, it also includes a person who's pregnant, someone who's getting ready to have a child, cannot treat people differently on the basis of familiar status. Next slide, please. And so now, go ahead, Karen.
Can you hear me now?
Yes, now you're back.
Sorry, everyone, my microphone has been temperamental, so I apologize. But before we watch this next slide, we just kind of want to get maybe a temperature check here. We want to get a little bit of engagement. So maybe through the chat box, if you guys can remember how many protected classes are under the Federal Fair Housing Act. If you guys could put in the chat box, how many protected classes are there, the number? Looks like we see a number of sevens. Awesome. Okay, great. Thank you. Yes, so 7 protected classes, and sex is interpreted broadly to now also include gender expression, gender identity, as well as sexual orientation. One more question we want to throw out to our wonderful group here is, take a guess. Nationwide, typically, what do you think is the area or the protected basis that the number one, the most amount of complaints, the majority of cases within HUD, what protected class do you think it is? If you could throw it out in the chat box. Good, I see some comments coming in. Someone mentioned color, race. Let's hear from some others too. Color, race. Okay.
Race.
I see familial status. Race.
Children. Race.
I see a sex as a protected basis.
Sex.
Okay, great. We love the audience participation. We know that
Disability.
and someone mentioned disability. So what nationwide, the number one area of complaints filed, despite the history, we can see that race and color really was pushing sort of the act itself, the historical context, but the number one area of complaints is disability. So we'll see that a high number of complaints is disability. But the focus for this training, we are going to be focusing primarily on race and national origin and color. But thank you for your audience participation. So maybe we can now turn it over and see a quick video called Do You Still Like Me? Thank you, Jen.
Let's play a game. Let's pretend for a moment. You own an apartment building. I want to rent from you. I have a steady job. I make a good salary and have a good credit history. Would you rent your place to me? How about now? No. Do you still like me, or have your opinions changed? What if I have an accent or a last name that sounds foreign? What if I have a disability? What if I'm a single parent? Would you steer me away? Would you close the door? Would you?
The Fair Housing Act protects your right to live where you want, no matter what race, color, national origin, sex, religion, disability, or family status. If you think you've been discriminated against, call us. Fair housing, it's not an option, it's the law.
Talani?
Yes, I'm here. Okay, so who can be sued or who can be named in a complaint, a fair housing complaint? Well, as Carrie Ann has mentioned a number of times already this morning or this afternoon, that the laws are pretty, the Fair Housing Act is interpreted and is pretty broadly. And so here are some examples. Clerical staff, maintenance staff, landscapers, vendors, neighbors, tenants, landlords, owners, managers, real estate agents, brokers, newspapers, insurance companies, mortgage companies, banks, lenders, architects, developers, homeowners association, government entities, police departments, and the list goes on. Why is it so broad? Why is it so comprehensive? Well, because the Fair Housing Act covers the sale, the rental, the financing, just about everything related to residential real estate. And so you see the list is pretty broad, pretty elaborate. And so we try to let people know, because oftentimes people believe that, when they hear about the Fair Housing Act, they're just thinking about rentals or maybe, you know, real estate agents or sales, but it includes like municipal services. And so that's how you have police departments and fire departments that have been named in and part of fair housing cases. Next. Okay, and adding to the broadness and the scope of the law is that the Fair Housing Act includes a wide range of housing, and it should be probably program providers, you know, programs such as the land trust that involve residential real estate would be included under the Fair Housing Act. But it also includes things like domestic violence shelters, dormitories, group homes, emergency shelters, homeless shelters, and many other types of residential real estate. Next slide. You're muted, Carrie Ann.
Who can file a fair housing complaint? Can you hear me?
Yes.
Okay, so anyone who has a good faith belief that he or she or they have been discriminated against. So it could be applicants, it could be residents, tenants, it could even be guests, fair housing organizations, it could be testers, people pretending to be of a particular class, real estate agents, employees, and others. Again, it's intended to be a remedial statute, which means it's very, very broad as to who can file a fair housing complaint. Next slide, please. And sometimes the question comes up, well, why would anyone want to file a complaint? You know, in some situations, people may try to resolve the matter just on their own sort of mediation, facilitation, conversation. But in some cases, there may not be any remedy involved, or there could be a denial of any wrongdoing. So a person may decide that they are a member of protected class. They decide to file with HUD. They believe that they've been treated differently because of their protected class. And that person's or an organization, because an organization can file a complaint accused of treating them differently, that are all covered by our fair housing laws. And I can share with you, just based upon experience, sometimes individuals are just looking for an acknowledgement that they were treated unfairly, and they may want a change in policies or practices so that others may not go through the similar experience. And sometimes parties start digging in their heels rather than mediate. They sort of get in this entrenched positions like, we've done no wrong. And sometimes a simple apology and coming together to resolve the matter can help to address the situation. And that's where we do really encourage the parties to conciliate and reach an agreement. Next slide, please. Okay, Jelani?
Yeah, so now you see we're slowly progressing. So now we're going to talk about, well, what is discrimination? What is meant by treating people differently or different treatment because of one's protected class, all of the 7. So this would include things such as refusing to rent or to sell housing. And if you're refusing to rent or to sell or negotiate because of someone's birthplace or ethnicity or ancestry, that would be an example of discrimination or potential discrimination based upon national origin. Setting different terms, conditions, or privileges for rent or sale of housing because of someone's race, disability, national origin, familial status. Falsely claiming that housing is not available. That's what we simply call like lying, but you're lying to a potential housing seeker because of their race, national origin, disability, familial status. Advertising or making statements that show a preference or indicating, discriminatory reason or preference, discriminatory reason, or there's one other area that goes into advertising. Preference, discriminatory statement. What's the other one?
Limitation.
Or some kind of limitation. Okay, thank you. Providing different housing services or facilities because of someone's protected class status. threatening, intimidating, or interfering with anyone's exercise of their fair housing rights. And those rights would include filing a complaint, being involved with the filing of the complaint, or if someone requests reasonable accommodation or modification because of their disability. Those are all what we consider protected activity, fair housing rights to do those things. And finally, if someone is being harassed because of their protected class, I can give you an example of that. If someone was being harassed because they speak another language other than English, that would, or that could possibly be harassment based upon someone's national origin. So now we're going to continue going through some examples of what does discrimination look like under the Fair Housing Act. So now this slide tells us about refusals to sell or to rent. And again, it's always because of someone's protected class, one of the 7 under the federal law. So if someone is refused, if there was a refusal to show available housing because of someone's protected class, well, that would be or could be deemed discrimination under the Fair Housing Act. If you're telling qualified applicants units were not available when they were available because of their protected class status, race, disability, sex, gender, familial status, that would be considered discrimination under the Fair Housing Law. Making home seekers feel not particularly welcome because of their protected class. That's kind of like a very subtle distinction, but things like that do happen. Making discriminatory statements which indicate a preference, limitation, or just flat out discrimination based upon someone's race, color, religion, national origin, disability, familial status. Delaying tactics such as manipulating waiting lists or delaying action on applicants because of someone's protected class status. You know, generally when there's an application, whether it's in a program like the Chamorro Land Trust Restoration Program, or if just like a application for a rental, you know, there are time factors considered in situations like that. But if there are delays or tactics to manipulate someone's application because of their protected class status, that would be covered by the Fair Housing Act. And finally, telling one person a price was firm, but you know, you're willing to negotiate with others, and that stance or that negotiating tactic is because of someone's protected class status, then that would be covered by the Fair Housing Act. And even though we're talking about refusals to rent or to sell, but it also includes negotiations. Next slide, please. You know, I wanted to mention that, remember I was saying about the 6 cases in the last 10 years that we've seen originate in Guam of complaints of housing discrimination. 2 of those cases had to do with refusals to rent. 2 cases had to do with refusals to sell and negotiate. And then there were 2 cases that had to deal with zoning and land use. So this slide tells us examples of different terms and conditions. Demanding higher rents, deposits, or applying different terms and conditions because of someone's protected class status. Prohibiting families with children from renting units that are on upper floors, or limiting families with children to lower floors. That would be covered in the Fair Housing Act under familiar status. Requiring disabled persons to have liability insurance while you don't require such insurance for others would be discrimination based upon disability. Prohibiting children from using the pool or other amenities just because they're children would be an example of different terms and conditions, discrimination under the Fair Housing Act. Next slide, please, Jai. Okay, so here are some examples of denying availability. Telling a qualified applicant that units were not available when they were in fact available, and that action, or they're being told that because they're being regarded or perceived as a person with a disability, or because of their color or their race, or another protected category. Only showing model apartments when actual apartments were available. That's kind of subtle form of discrimination to kind of discourage or not provide truthful, accurate information because of someone's protected class status. Next slide. Okay, now, ladies and gentlemen, we're at the time for another video. This video is a little longer, but it's pretty comprehensive. It gives some good examples of the law, how it evolved, and it goes up to 2018, I think it is.
Okay, just give me one moment and I'll pull it up. I apologize.
No, take your time, no problem. If anyone has any questions or any comments, I'll check the chat at this time. Nope, I don't see anything. Okay.
As we're watching the video, if particular questions come up or if something appears to be confusing, please put those questions or comments in the chat box, and that will be a prompt for us to answer those questions or any concerns.
And here's the video.
For the life of me, I don't know what's make it so hard to have assistance animals like my dog Alex.
My last apartment, the building manager was a real problem. When you have access to so much information, you have the responsibility to be very careful how you use the information and share that information with clients in the MLS. Hello, I'm Sandra Ortiz. Welcome to this edition of Housing Point. Today, we'll be discussing the Fair Housing Act in honor of its 50th anniversary in 2018. President Lyndon B. Johnson signed the Fair Housing Act on April 11, 1968, just days after Martin Luther King Jr. was assassinated. Dr. King was the country's most notable proponent of fair housing, marching in the streets of Chicago in 1966 to end the years of housing discrimination experienced in communities across the country. The Act currently prohibits discrimination concerning the sale, rental, and financing of housing based on race, color, religion, sex, disability, familial status, and national origin. In honor of the 50-year milestone, we'll address ways that the Fair Housing Act protects real estate professionals and your customers, and to help you navigate responsibilities under the law. We'll also look at how the Fair Housing Act addresses harassment and retaliation in the housing context. Finally, we'll review the best practices for criminal background checks of housing applicants. Our first story profiles a veteran who has an emotional disability and wants his assistance animal to live with him. Many landlords still aren't familiar with the Fair Housing Act's requirement that housing providers accommodate tenants who require assistance animals. Horace Miller reports from Chicago.
Philip, a Marine veteran, is joining me today along with his assistance animal, Alex. Philip and Alex have been a team for 6 years. After serving tours in Iraq and Afghanistan, Philip was wounded and developed post-traumatic stress. Now Alex helps him get through some very difficult days and nights.
Alex is a part of it. I really can't imagine life without him. Somehow, he always knows when I'm having a bad time. Like last night. He woke me up so I didn't start having a nightmare. And before Alex, I would wake up thinking I was in the middle of a firefight. Not anymore. It's one thing that keeps me calm.
And your doctor suggests you benefit from an assistance animal like Alex?
Correct. My VA doctors have eliminated most of the medications I used to take since I started using an assistance animal. One of my doctors even said, my dog is the best medicine for me. But try telling that to some of these landlords.
Landlords and building management need to be aware of the law. They are required to accommodate people with physical or mental disabilities and permit them to have an assistance animal, even when a building has a no pets rule. If a tenant with a disability makes a request for an exception to the rule, building management must accommodate them. Unless there is a threat to the health and safety of others, the housing provider should consider and grant the request. Any animal that provides a disability-related service to the disabled can be considered an assistance animal, even monkeys, birds, or reptiles. Your building has a no pets rule. So what did you do to support your request for an exception?
Since my disability is post-traumatic stress, which isn't something you can see, I provided management with a letter from my VA doctor. Now, the letter explains that I have a disability, and Alex provides me with disability-related assistance.
Well, that should be all you need to have your animal live with you, right?
You would think so, but then the landlord wants to know what my disability was, what medication I was taking, and some other health-related information, which I didn't think was any of their business.
According to the Fair Housing Act, housing providers and real estate professionals are not allowed to ask for information regarding medications, copies of medical records, or any details about the nature or severity of a person's disability. A letter from a doctor detailing the patient's need for an assistance animal should be all it takes to allow for an exception to any no pets rule. Of course, there are some people who try to exploit this right, and fake documents can be obtained from uncredible sources. If you suspect that documents are not credible, make a written record and advise the property owner of your concerns. Then have them advise you regarding next steps.
For more information about the accommodation for assistance animals, visit fairhousing.realtor. Our next story concerns a mom who not only had to deal with harassment and retaliation from her landlord, but also another problem: discrimination against families with children, a protected class under the Fair Housing Act.
Anne is a divorced mother living with her 9-year-old daughter, Casey. She thought she had found a perfect apartment for the two of them. But soon after moving in, the landlord began to harass her.
Jack, I can't hear the volume.
Maybe because you're muted, Jack.
May be enough evidence to constitute a crime. The Fair Housing Act also prohibits retaliation against anyone who reports a discriminatory housing practice. Now Anne wants to find a different one-bedroom apartment for herself and her daughter, but she's running into something else: landlords who don't want to rent to her because she has a child living with her.
First, I had to deal with management companies that don't want to rent to families who have kids.
Isn't it against the law for them to even ask if you have children?
I have ways of finding out. Social media, for instance. And usually they'll ask the ages of everyone in the family on those applications that you have to fill out. Or they will ask you, so how old are your kids? Out of the blue. And then before you know it, you're answering without even thinking. And then suddenly they don't have any apartments available to rent right now or ever. That's why I only give our names. And sometimes landlords will actually say in their ads that they're renting to adults only, or they will imply that they don't want kids.
Familiar status is a protected class under the Fair Housing Act, making it unlawful for housing providers to deny housing outright because a family has children living with them under the age of 18. These same protections apply to families who are expecting or adopting children. Additionally, housing providers may not restrict families with children to live in certain areas of the building complex, or refuse to let them use certain facilities. There are exceptions, including certain types of housing designed just for people 55 years or older. But for the majority of people looking for a place to live, the ages of their family members should have no bearing on their ability to find a home.
My family's just my daughter and me, so I want to rent a one-bedroom because I'm on a limited budget. Even though there are buildings that allow kids, I was told that I have to rent a 2-bedroom because there are 2 people in the family.
But I'm sure they must allow people who are roommates get a 1-bedroom. And what about people who are married?
Exactly what my broker said. Amazing how easy it was to get a 1-bedroom when she brought that up and made it clear that we need the law.
To learn more about the Fair Housing Act's protections against harassment, retaliation, and discrimination against families with children, visit fairhousing.realtor. Our final fair housing story is about big data and its link to steering. I don't have to tell you, big data is everywhere. It's in your pocket, it's in your wallet, your house, your car, and of course on social media. Big data helps you offer enhanced service to your prospects, but it can also lead to accusations of steering. Horace Miller reports from San Jose, California.
In real estate, data about properties and customers is readily available, and what used to take months to collect, organize, and analyze now takes only minutes or even seconds, and it seems to grow exponentially every day. There are even a number of services that aggregate all the data for a property to make it useful for a single housing transaction.
So what kind of information is available to you?
Before you even meet or speak to a client, you can learn their race, color, country of origin, disability, sexual orientation, familial status, and religion without much searching. But that same information can also be used to discriminate.
Interesting. How so?
With so much data available about a prospect, you have to be extra careful not to use that information in a discriminatory manner. You also have to be very careful to avoid steering. So steering is when a real estate professional guides a prospect to or away from a particular community or a type of housing based on their race, ethnicity, or another protected class. In every instance, we are always obligated to provide our clients with equal professional services.
So what's the best way to avoid this?
Use the equal professional service model. Ask yourself, do I have objective information from my customer about the kind of house that they want to buy? Have I let my customer set the limits on the size of the house and its location? Have I offered them a variety of homes to choose from based on their preferences?
So what about brokers who run ads for their houses on social media?
Well, before you write anything, you want to be very careful not to target ads to or away from protected classes. Otherwise, you could get into trouble for steering. When you write an ad for a house, you want to describe the property by highlighting the positives of the housing, not the ethnic makeup of the neighborhood or desired characteristics of a potential buyer.
How about when you're meeting with clients face to face?
Well, you want to ask the customer about their needs, size, style, features of a home, types of schools, convenient transportation, where they can shop. You want to avoid questions about their religion or ethnic background. And remember, you're there to help them find a home based on their individual preferences, not yours.
So what if someone wants to know about the quality of the schools in the area?
Well, you want to avoid making a value judgment about the quality of schools. Even with all the data that we have, opinions on schools' quality can be very subjective. Instead, maybe refer a potential buyer to the website of the school district so that they can do their own research based on their needs. You want to let the client set their own limits.
You must get a lot of questions about the crime rates and the demographics of different neighborhoods.
You want to avoid discussing crime rates or the demographics of the people in an area. If a client wants to know about demographics in the area, direct them to the Census Bureau website. Don't discuss the race or the religion of people who live in the neighborhood. And same with questions about crime rate. I always suggest that they talk to the local police or go to the library or use the internet so that they can find the facts. A broker should never say that one area is safer than another.
So you suggest giving a client the tools to find their own information and make their own judgments.
Well, in the end, I think that's more helpful. And also by offering a variety of choices, you avoid unwittingly excluding property that the customer might like. In the end, it's up to the client. If you are pressed by a client for your opinion, always be professional. The more subjective a question is, the more risk there is to give an inappropriate or even unlawful answer. Ask them what their concerns are and then refer them to the appropriate sources of information. You want to avoid making judgments, offering opinions, and sharing your perceptions. Tell a client it's your policy to help them make their own decisions. So even with an abundance of data at your fingertips, remember that any decision should always be left to the client. It's best for them, and then you can avoid trouble with the Fair Housing Act. For more information on big data and how to avoid steering, visit fairhousing.realtor. Horace Miller joins me now via satellite to discuss criminal background checks. So Horace, what have you learned in your travels around the country?
Well, Sandra, the criminal background check issue poses a pretty daunting problem for people with a criminal history, as some individuals still seem to have trouble getting an application approved to rent an apartment.
That doesn't seem fair.
It's more than not fair. In some instances, it can be illegal.
How should real estate professionals handle these situations?
Landlords should implement a written policy for criminal background checks of housing applicants and apply that policy consistently to every applicant. A written policy gets everyone on the same page. It makes clear that the same standards apply to everyone, and it should be crafted with the safety and protection of all residents and property in mind. At the same time, it's against the fair housing laws for management companies to have a blanket ban on anybody who has a conviction.
So what kind of information should a housing provider be looking for when formulating a policy?
A landlord should allow an individual to provide additional information and should consider a number of factors when evaluating a housing applicant's criminal history. For instance, how long ago was the conviction? 5 years, 10 years? Avoid looking back indefinitely into a person's criminal history. How old were they? Were there any extenuating or mitigating circumstances? Have they been through a successful rehab? Was the crime a misdemeanor or a felony? Was it violent or nonviolent? And a housing provider should never consider arrests as part of the applicant's criminal history. To sum up, real estate professionals and management companies have to weigh the protection of the residents and property as they evaluate someone with a past conviction. A good policy helps those who have paid their debt to society find a place to live.
Thanks for the excellent report, Horace.
Thank you.
For more information about criminal background checks, visit fairhousing.realtor. The National Association of Realtors has set an exemplary standard for equality in housing, which its members are obligated to uphold. In fact, NAR's Code of Ethics goes beyond the federal fair housing law and some state laws by prohibiting discrimination by its members based on sexual orientation or gender identity. And realtors do not take their responsibility lightly. Even when a state law does not prohibit discrimination against a client that is a member of the LGBT community, a broker's participation in such discrimination would run against their ethical obligations under NAR's Code of Ethics. As a leading advocate for fair housing, the National Association of Realtors has taken a clear stance that everyone deserves the equal right to purchase or reside in the home of their choice without regard to sexual orientation or gender identity. Each of NAR's 1.2 million members have made a commitment to upholding this idea. 2018 marks the first 50 years of this groundbreaking legislation, which gave everyone the right to be in the housing of their choice. We leave the next 50 years in your capable hands.
All righty. Welcome back, everyone. It looks like there was at least one question in the chat from Glenn, who asked, does the family, does the family pet such as a dog qualify as an emotional support animal? And Carrie Ann said she'll respond. Carrie Ann, your answer to Glenn's question.
So we will, can you hear me?
Yes.
Okay, so we'll jointly respond. So Glenn, thank you for asking that question, because we get many, many questions relating to assistance animals, which is the term used under the Fair Housing Act, where individuals make a request for a reasonable accommodation to have an assistance animal to help them to have equal enjoyment and access to fair housing, either their home or common areas. So what are the cardinal rules within fair housing? And that during some of our trainings, we spend a lot of time on assistance animals. We want you to leave this training with the message that an assistance animal is not considered a pet. So under the Fair Housing Act, an assistance animal is not considered a pet. An assistance animal typically can be an animal that has been trained for a particular function. It could be an animal that has assist a person, a medic alert, maybe notifying a person that they have to take their medication or before someone has a seizure. The animal can be either trained by an outside party or they could be trained by even the individual. And intuitively, some of these animals just know how to alert individuals. They can sort of read moves. In the movie, you may have heard the gentleman say that he would sometimes have nightmares, maybe relating to past traumatic experience, relating to military experience. We know of animals that have been trained to wake up the individual while they're having nightmares if they have post-traumatic stress disorder. So again, the answer to your question is that assistance animals is the term that we use under the Fair Housing Act, but sometimes people also use the term emotional support animal or therapeutic animal. Jelani, would you also like to elaborate on that?
So I'll just elaborate by simply stating that if we're looking at your question, Glenn, from the standpoint of whether an animal, such as an animal that functions as a pet, like a dog, could be construed as an emotional support animal, i.e. assistance animal, the simple answer would be yes, that is possible, because emotional support animals are animals just by the very nature of their presence provide some emotional support for an individual's disability. But the thing we want to be careful about is saying that it is a pet, because legally, technically, it's not going to be considered a pet. It's going to be considered an animal, an assistance animal, which provides emotional support for someone's disability. Therefore, it would be exempt from, no pets policy, as well as any kind of conditions or requirements related to pets. So if someone has an animal, and just by virtue of it being an animal, it provides emotional support, which is related to someone's disability, then that animal could be considered a emotional support animal or an assistance animal. Therefore, they would be allowed to have that animal because of their disability-related reasons. I hope that answers the question. So now we're going to talk a little bit about advertising. We've mentioned it a few times already today, but advertising it's unlawful to publish or cause to be published an advertisement that expresses a preference, a limitation, or discrimination based upon a protected category or protected class. So this picture gives an example. So you can't say no kids, can't say no blacks. That would be racial or color discrimination, or both, racial and color, and then no Latinos, that would be national origin discrimination, and no kids would be discrimination based upon familial status. And so you can't advertise, and advertise again includes any kind of statement that's spoken or published that indicates a preference, limitation, or discrimination. Next slide. A little more on advertising. Again, this slide breaks it down even. What does publishing mean? What can be in the newspaper? It can be a handwritten ad. It can be an eviction notice, newsletter, posted on a bulletin board, verbal statements. We get a lot of those verbal statement kind of complaints where someone says, no, we don't allow, or, we don't want your kind. And it can be listed on an application. And so here are some examples. We prefer to rent to Japanese. We only rent to people who speak English clearly. That would be discrimination or discriminatory statement based upon national origin. Ideal for singles. That may mean individuals without children or families with children. We don't rent to anyone from the lower islands. Now that comes from a situation in Guam where one of our investigators some years ago was over in Guam and investigating a case, and someone made that statement to her that they were making a distinction based upon people being from the COFA or Micronesians from the quote unquote lower islands. The unit is too small for you and your children. Again, that's based upon familiar status. And we don't rent to people with assistance animals. So that would be based upon disability. So we can't make statements that indicate limitation, preference, or just flat out discrimination.
Maybe if I could add to that and just elaborate. So even if the individual who's making the statement, whether it's verbal or if it's published, and again, this was probably an older slide. We know with social media, it could be a text message sometimes, or it could be posted on Facebook or Twitter or whatever other type of social medium that's being used. I just want to point out that if the individual who's making the discriminatory statement, even if they are mistaken, but it relates back to the protected basis, there can be a violation of the law. So let me give an example of that. What if someone is, in a situation or a place and someone makes a comment like, well, I don't want to rent to you because you're, I don't want to rent to Mexicans. And I'll give an example. Let's say when I was going to college in California, where I did my undergraduate studies, typically, even though I'm not Latina, I'm not Mexican ancestry, but when I was in the continental US in California, I was often perceived as Hispanic or Mexicana, Latino. So even if the person is mistaken in their belief, that can be a violation of the law because the comment is relating to either race, color, or national origin, even if the person is mistaken. In another case recently that I did an intake, a woman was alleging harassment on the basis of national origin. The woman is from Cambodia. She's an immigrant, but the individual is making discriminatory comments and slurs and calling her Chinese, even though she was not of Chinese ancestry or national origin. So I just want to clarify that because wherever we are, we may be protected. You may be in Guam, but if you or your children or your family members travel to other places within the US or other territories, and there is a misperception of your race, national origin, color, you would still be protected. And that does happen in different contextual circumstances.
Yeah, interestingly enough, I had a case many, many years ago. This was on the mainland, and it resulted in going to court, actually. And an individual made these statements, and he said he didn't want to rent to any people that were Guamanians, that were Chamorro, that were Pacific Islanders, and this was like a single-family home. So the Carrie Ann's point is one that is well made, well taken, because sometimes when we do these trainings, people think in the context of work that they're doing, where they're located, but the Fair Housing Act includes all of the states, all the territories, all the commonwealths, and so these things have a tendency to spread throughout the land, and so one of the things we always like to do is to heighten people's awareness. So if you, your family, or someone else you may know experiences statements, discrimination in this form, know that there are laws that protect them from such conduct, behavior, and statements. Next slide. You're on mute.
Okay, can you hear me all right?
Yes.
So as you may recall, this earlier today, we focused on the 7 protected classes or groups or bases. And you likely did not see the word retaliation listed as a protected. So it's not a protected class per se, but it is a violation of the Fair Housing Act if a housing provider discriminates or retaliates, interferes with, coerces, or intimidates a person and subjects them to adverse treatment because the person exercised any rights granted by the fair housing laws, they opposed the discriminatory practice, or they filed a fair housing complaint or assisted in filing a complaint. And we often highlight this particular area of the law because behind the number one area of filed complaints under the Fair Housing Act, which is disability, the number two area where we see complaints is relating to retaliation. And we've included the statute here. If any of you would like to look at that, it's Section 818 of the Fair Housing Act, prohibits these discriminatory acts under retaliation. Next slide, please. So we want to give you some examples of what retaliation or coercion, intimidation may look like. So one particular example may be where an individual is being evicted for reporting discrimination to the landlord, or maybe they're filing a complaint with HUD or even the Department of Justice. Another situation may be retaliatory conduct against a real estate agent who is refusing an owner's decision to discriminate. So let's say the owner who's selling a home may say, well, whatever you do, don't rent to this quote group of people. That real estate agent could file a claim under the Fair Housing Act in support of their rights. Another situation may be where an individual is subjected to vandalism, threats, violence directed against them for participating in a HUD or DOJ investigation. Another example of retaliation that we see is where a tenant's rent or program fees may be, there's threats for increasing them when they refuse an owner's sexual advances. So these again are just examples. Retaliation takes many different forms, but what we want to highlight here is that it is a legal claim under the Fair Housing Act. It is the number two greatest area of complaints, and that is independent of the other protected classes. So what do I mean by that? Let's say an individual files a fair housing complaint and they're alleging discrimination on the basis of sex or some other protected class. And we start the investigation. Even if ultimately we conduct the investigation, there may not be enough evidence to support a finding of cause that there's a violation of the law. So then maybe the case would be dismissed because of no cause determination. That person could still file another complaint, or in the same complaint, allege retaliation for filing a complaint or opposing what they believe to be discriminatory conduct under the Fair Housing Act. And we always emphasize this, is that sometimes there may not be evidence for the underlying protected basis, but there may be sufficient evidence to show a violation under retaliation. So this is a cautionary tale for all housing providers. Next slide, please.
Okay. Time for questions and answers. Anybody have any questions? Let me look on the chat here. I'm not seeing any questions. Anybody wants to unmute themselves and ask a question, then now would be the time to do so.
Yes, and maybe we can also hear too from our other HUD counterparts, Catherine and Rebecca, because there might be some other scenarios that they want to share collectively. Catherine.
Yeah, I do have one. And I think I actually shared this with Jelani a few years ago, and that was I had a situation where a prospective renter called and asked if it was okay that the place she wanted to rent from, that the landlord in question told her that she should rent on the first floor. And that was because she had a child. She had a young, like a toddler. But that same landlord had families with older children on the second floor of their building. And when I spoke with the gentleman, he said that his reason is because it would be unsafe for a younger child to be in that building. And they had outside corridors and all. Well, we tried to. My point to this is that obviously it's not allowed, that he could not direct you to not rent where you wanted to rent. And even after the woman said they were fully capable of taking care and making sure that their child was going to be, watched in the common areas and in the unit. But my point is that he didn't do it as a form of, intentionally wanting to cause discrimination, but he had to be counseled that what he was doing was still discriminatory for that family, and that it had to be something that he had to put aside and let things happen. He had clean walkways; they were properly kept. He had put other kind of reinforcements in the hallways and even on the balconies for houses, so that they could keep their children safe. But for whatever reason, he had this threshold in his head of what was considered safe for that family. So it's not always a malicious intent. It could be very, very, with good thoughts, but not compliant.
Right. That's a good example, because sometimes the different treatment is not for the protected class as a whole, as you mentioned in this case, in terms of familiar status. It may be, the protected class based upon some individual characteristics like the ages of the children or the number of children, or as in this example you're giving, Kathy, in terms of considerations that the housing provider had for health and safety concerns. But the golden rule in civil rights and fair housing is, those types of considerations are left up to the applicant, the individual, or the family, how they're going to deal with those safety concerns. And, you give them an opportunity to see and rent out the property just like anybody else would. And if the landlord or housing provider has concerns, then you just point out those concerns equally across the board to everyone of the potential risks or dangerous features of the property.
Mm-hmm.
And I just want to follow up. Thank you for sharing that, Catherine, because I think what's really important to emphasize too is that a violation of the Fair Housing Act does not require malicious intent. It doesn't require bad intentions, and in some cases, people have good intentions in mind. In particular, that case that you shared. So again, it's not trying to blame to malintent, but just to say under the Fair Housing Act, family members should be able to make decisions upon what's best for their family and not steer them to any particular unit based upon the housing provider's idea of what is safe or not safe for the family. So letting the parents or guardians make that decision. Thank you, Catherine. Other questions, comments, feedback? It could be even a question or an area that's confusing. This is a great opportunity for us to learn from one another. Okay, so I'll read out the question. Jelani, it looks like Johanna, and I apologize if I'm mispronouncing your name, in reference to Public Law 35-112, specifically based on page 7, how would you address an individual wanting to apply for Tomorrowland Trust Commission but cannot show proof of eligibility and then tells us that we are not being fair to them, especially because they've been staying on the property for many years?
Wow, that's a good question. One of the things that we tell all housing or program providers is that you want to create an environment that gives applicants, participants, a understanding or a sense of the fact that we are complying with the fair housing laws. And oftentimes you find, like I reading this question, is that people have a tendency to equate fairness, just the general concept or notion of fairness, with the fair housing laws. So when they hear fair housing, they may think it's landlord tenant. They may think it's a whole lot of things, because fairness is a term that we use indiscriminately throughout society, but it has a particular legal meaning in the context of civil rights related to residential real estate. So what I would say in terms of responding to a question like this, or a concern that somebody's raised, about their eligibility? Well, if as we move forward, we know that eligibility is not based upon race, not based upon national origin, not based upon familial status, disability. It's not based upon any of the areas that are protected by the fair housing law. So I would point that out to the individual who is bringing that and try to, engage them to address what their concern may be. And in that way, we are educating the consumer. There used to be a commercial I used to really love. It was back somewhere on the mainland, and it wasn't housing. It was some kind of maybe it was like a real estate company. They used to say that an educated consumer is our best customer. So you want to let the customer or the program participant know, look, I've been through fair housing training with Carrie Ann Shirota, with Catherine Taitano, with Jelani Madaraka. And so, I have a basic understanding of what the law is, but sometimes we may get it wrong. Well, can you explain to us what you mean about how, you're saying that, you're not being treated fair? Because just based upon what we have here in the question, there's no indication that there's no housing discrimination based upon, what this person's concerns may be pertaining to, their eligibility, because we know moving forward that eligibility is not based upon any of the protected categories in the Fair Housing Act. So you would want them to point out to you, like, what their concern is. And if that doesn't work, ladies and gentlemen, then direct them to Kathy Taitano, who is our fair housing coordinator, because she does an excellent job at addressing questions like that. Because oftentimes she would tell you that, a lot of people call up and they think things are unfair, that this landlord-tenant issue or something else, but it's not really fair housing. So there's this ongoing education component. And sometimes when it's coming from the housing or the program provider involved, they think that you already may be biased. So if you could direct them to Kathy or to Carrie Ann or to myself or someone who has the knowledge and expertise outside of your organization that can, engage them and clarify for them what does fairness mean in this context of the Fair Housing Act and in the context of, general eligibility concerns. Because if eligibility is not being based upon a protected category, then they just may have a general notion of what they, are complaining about. And Carrie Ann will tell you, she's done some time fielding those questions when people want to file complaints. A lot of times people are just mistaken and they're just frustrated with the wait time. They think that that's discriminatory. They're frustrated with, where they are on the list, and a whole lot of things that they feel are unfair, but it's not fair housing.
Yes, and I would just add, I think it's really important. I don't know if it's on your website or other places where you have materials, whether it's brochures or on your website, to show what the criteria is and making sure that people can see it. And then if they are challenging eligibility, what is your process? And to consistently apply the process to all persons who may feel that it's unfair towards them. In this case, the example that's listed is that they've been staying on the property. So, it's not the exact same thing, but there is a Hawaiian Homes Commission here, right, in Hawaii. And some people qualify under the criteria and some people do not. And there are also concerns by some individuals who believe that they're being unfairly treated or because they're not being able to prove genealogy. So it is a little different. That's a congressional act, but I just say in general, we always advise people, have a policy of your criteria, make sure that it's available for people to review and to see clearly, and then to have a process if people are challenging or inquiring about that, and then to evenly and equally apply that process.
One other thing that comes to mind is that, one area that we focused on today had to deal with different treatment, right? So sometimes, and that's probably one of the number one areas where we receive a whole lot of complaints that for some reason people feel that they were treated differently with respect to their protected class category or status, right? And so in engaging them and trying to find out, well, how is it that they feel they're being treated differently? it may not be something that's said or stated in the eligibility criteria. It may be in the application, and somebody has some notion or some idea that because of their protected class status, right, that all they're being passed over, or the eligibility criteria is being applied differently to me because of one of the 7 areas that we've talked about. And so that's the reason why I would recommend as the best practice to try to brainstorm with the individual and to try to find out what do they mean by this unfairness? Because oftentimes, you know, when we look at different treatment, it's not something that someone said. It's the way that a program may be administered, and we look at comparable data to make sure, with respect to people's protected categories, that there is this, you know, equal treatment across the board. Okay, well, if no one has any more questions, we have some questions for you, because they say turnaround is fair play. Jack, can we continue with the PowerPoint?
Coming right up. I'm presenting right now.
Okay, well, while you do, I'll start reading it before you even pull it up.
It's coming up in a second. Okay, here we go.
Okay, question number 1. And you can unmute yourself to answer the question if you like. I think that would probably be the easiest. It says, under the Federal Fair Housing Act, which are not protected classes?
E and G.
Income.
Source of income.
C.
Handicap, disability, familial status, color, sexual orientation, origin, sex, gender.
Source of income.
Had a hand up. Okay, I see source of income, that's correct. That's not currently covered under the Federal Fair Housing Act. Sexual orientation, someone said. Well, as Carrie Ann covered, as we talked about, sexual orientation is not covered directly. It comes underneath the interpretation of sex. So sexual orientation would be covered, but not just under sex or gender.
So why did you put sexual orientation?
Right, so maybe if I can clarify that. So if we were to pull out the statute of the Fair Housing Act or even the federal regulations, we do not see the words gender identity or sexual orientation as an explicit, so it is not specifically outlined as protected, but the United States Supreme Court interpreted the Fair Housing Act to encompass and to be interpreted to include and protect gender identity and sexual orientation. So that is currently the interpretation. So, you know, if you look at the statute, you don't see sexual orientation and gender identity, but by the Supreme Court's analysis and case decision, the Fair Housing Act covers those areas. So for this particular case, its C source of income is not protected. But as we mentioned earlier during the training, there are some states like California that protect source of income. So if somebody's getting a fair housing voucher and a landlord does not accept them as a resident or has a posting, no, you won't rent to Section 8 tenants, then that would be a violation of their law under the state law, but not the federal law. But we just want to make sure that we're clear about that, because it can be a confusing source, again, because it's not listed in the statute, but it is covered by interpretation of the Supreme Court. And this Supreme Court decision is like about a year old. So a few years ago, gender identity expression and sexual orientation were not covered even by interpretation years ago, but that has since changed. And that's why we want to emphasize the importance of doing fair housing training every so often, because the law does change and evolve. Even the census that we mentioned earlier today, 10 years ago, the census did not have a category for multiracial. People had to pick one category or the other. And there's many of us who may be participating here who do not fit into just one category of race. So the law does evolve and change over time in its interpretation.
Okay, next.
Right, adding to that, you know, the new administration, under the Biden administration, the president passed an executive order which directed all federal agencies to, address this sex and sexual orientation, gender identity, and expression. And HUD has recently came out with guidance indicating what we have already mentioned, which is under the category of sex, gender expression, and sexual orientation will be so little tricky. Next slide, please. Okay, true or false? Under federal law, indicating a preference based upon sex, gender, in advertising, an available apartment or room is perfectly legal. Any takers? False, false. We got all falses coming in so far. And the falses are correct. That is not perfectly legal. That would be discrimination based upon sex or gender. If you are indicating a preference or limitation or discrimination on the basis of sex or gender, that's going to be a violation of the Fair Housing Act with respect to making discriminatory statements. And a lot of people, they want to know when they see this question, they want to know, well, why is it that when they look on Craigslist, they look online, or they look in the newspaper, you see a whole lot of advertisements where people say they just want a woman, or they just want a man, or they just want, someone of the same sex as they are to rent out, an apartment or a room. Well, just because it's online doesn't make it legal, or just get printed in the paper doesn't make it okay. And that's so widespread that for a long time the department has only acted on those when those are brought to our attention and somebody wants to file a complaint. So several years ago, there was an organization, a national fair housing organization, that went around the country and took issue with all these kind of discriminatory acts, file complaints. So even though you see it, doesn't mean that it is okay. And so be aware of what you say, what you state, especially if you're indicating some preference, some limitation, or if it's discriminatory on its face.
Jack, Jack, could we go back one slide just before this? I think we skipped one. Yes, thank you. So I'll read this one out. True or false is if a housing provider unintentionally engages in discrimination, he, she, or they cannot be held liable under the Fair Housing Act. Is that true or false? If the housing provider unintentionally engages in discrimination.
Unintentionally is the key word. Cannot be liable under the Fair Housing. I don't know.
So we see there's a kind of a mixture, but it looks like most are false. So that is false. So as we shared earlier in the example that Catherine shared with us, even if the housing provider does not mean to discriminate, even if they may have good intentions, it could still be a violation of the law, which means they would be liable. So again, there isn't this intent that's under the law. You don't have to show malfeasance, malintent. There could be good intentions, but again, it could still be a violation of the law. So the answer is false. So if we could jump ahead to the 2 slides, Jack. Okay, true or false? A housing provider may turn down a Pacific Islander applicant because of the applicant's lack of a steady job and income. Is that true or false? Okay, so we're taking a look at the chat box. We see a number of trues, and the answer is true. So here on its face, in this fact pattern, it says that the person is of Pacific Islander race. And in some situations, a person can allege discrimination on the basis of race. But in this case, it says, can the housing provider deny if the applicant does not have a steady job or source of income? So if they don't have enough money to make the rent on a monthly basis, that is considered a legitimate, non-discriminatory reason not to raise to that person, even though they belong to a protected class based upon their race. So again, you could deny a person or not rent to them if they do not have what you deem is sufficient income to pay the rent on a monthly basis. Okay. And as Angela pointed out, it's not discriminating based upon race in that particular fact scenario. Next slide, please. And I'm going to turn it over to Jelani to talk a little bit more about enforcement and compliance and where it intersects.
Right. Okay. So we briefly mentioned some of this at the beginning, but we've gone through so much, so now we need to take it full circle. You know, for the most part, you know, the training that we are having today and on Thursday is dealing with the Fair Housing Act and the enforcement. But when the Fair Housing Act was initially passed in 1968, it required some affirmative obligations. And I did mention earlier that the Fair Housing Act requires the Secretary of HUD to ensure in all of its programs and activities it's consistent with the prohibitions of the Fair Housing Act. And so what does that mean? That means that within programs, activities that are funded by the federal government, funded by HUD, that it's a requirement that steps be taken to affirmatively further fair housing. And that's how we get Madam Taitano's involvement, because since GORA receives, you know, a good deal of funds from the federal government through HUD, along with the receipt of those funds is the requirement to take steps to affirmatively further fair housing to ensure that everyone, not just within GORA, but everyone within the Guam jurisdiction is, in abiding by and, not discriminating against or not interfering with people's what we call fair housing choice. So she does that in a number of ways, by being a resource, by doing education outreach, by answering people's questions, to, do affirmative steps, not just not discriminate, but to ensure that within the jurisdiction of Guam, that there is this compliance with the requirements of the Fair Housing Act. But that requirement only goes to those who receive either, direct funds from the federal government, direct funds from HUD. But the responsibility goes throughout the whole island, the whole of Guam. Next slide, please.
Before you go to the next slide, could I say something? This is Rebecca.
Yes, you can. Go right ahead, Rebecca.
So earlier, I mentioned that I work in the Office of Community Planning at HUD. So what I want you to understand is that, even though GORA is the agency in the government of Guam that administers these formula grants directly, really, these formula grants, it is the governor of Guam that executes the grant agreement with HUD. So for CPD, it's the government of Guam that is the grantee. So County talks about the requirement to affirm further fair housing applying to those who receive federal funding. For CPD, it is the government of Guam that's receiving this federal funding. I just wanted to add that in there. Thanks, Bonnie.
You're welcome. Thank you. And along those lines too, I don't want to put Kathy on the spot, but I just want to let you guys know that, in Guam, there is a local law which prohibits discrimination in housing accommodations. So you need to be aware, and you need to comply with the local and the federal law. And that helps overall with the government of Guam's compliance with the Fair Housing Act. Next slide, please. So we're talking about compliance again. We're not just talking about enforcement. So we try to get people's voluntary cooperation with the law by education outreach and by, soliciting the partners that we have that receive money directly to take affirmative steps to further fair housing. Next slide, please. Okay, so this slide talks about, we're going into a little bit on compliance now. So there are other laws that I've kind of made reference to today, in addition to the Fair Housing Act, right, which applies to most all kind of residential housing, residential real estate related transactions, right? There are other laws, civil rights laws that apply to those who receive federal funds, like Section 504, the Rehab Act, which prohibits discrimination against persons with disabilities, and the Americans with Disabilities Act. Well, there's a lot of overlap in these laws. And I know that the land trust, you have a relationship with USDA, RD, and they have some similar laws. So we try to bring these things to people's attention because there is overlap. And if you comply with, like, say, the 504, the Rehab Act, it's good measure that you'll be in compliance with the Fair Housing Act with respect to disability. Next slide, please. Okay, so we are just about out of time. As Jack mentioned at the beginning, that you all have some evaluations and to fill out, and you'll get them back to, I forget who you mentioned, Jack. You can remind everyone now.
Sure. Let's make sure to send it to Joey and Therese and CC myself so that we can collect all of the evaluations. I believe that they were sent to you today via email this morning as we began the presentation. And if I can, I will just bring it up so that you guys can see what it looks like. So it should be like this. It's a fillable PDF where you'll be able to click inside the boxes and provide your comments. And there's a drop down in each of the numbers. So 1 is strongly disagree, number 2 is disagree, 3 is neutral, 4 is agree, and 5 is strongly agree. So you make a selection and then share how each evaluation criteria can be improved for day 1. And then you save it and then send it to Joey and Therese and CC myself.
Well, I think that's about it for today. We thank you for your time, your participation, your cooperation, and we'll have a break tomorrow, and then we'll see you all again on Thursday. And when we get together on Thursday, we're going to focus more on race and national origin specifically, and see a few more videos, address any questions that you may have, and make sure you guys go away with a good understanding of the Fair Housing Act and how it may apply to your respective jobs and tasks that you perform for the land trust.
Thank you so much, Jamal, Marianne, and Ms. Kathy and Ms. Rebecca. I just wanted to give our chairman an opportunity to close before we officially sign off. So, Mr. Chairman.
Yeah, just thank you again, everybody, for the time and attendance today. Definitely a lot of stuff to learn. So appreciate the ability to get the recording in play and the documentation. So it's good stuff. Thank you.
Thank you.
Thank you, Mr. Chairman.
Add something. Okay, so sorry, I actually got bumped out for just a little bit, some internet difficulties here, so I apologize if I missed something. We want to thank all of you for participating, for your engagement. We're hoping that there's even more engagement on day 2. And we do have, in addition to your evaluation, we welcome your feedback because it really helps us to improve our fair housing training. But we also want to make it relevant and tailored to the communities that we serve. So if there are particular areas of the law that we touched upon that you would like some more information about tomorrow, we will do our best to squeeze it in where we can. So if there's an area that's confusing or you would like us to reiterate something, we will again focus more in detail on national origin and race. But I've also asked that starting up on day 2, we typically do a quick welcome and we do a round robin where we may ask, well, we're going to ask you to participate to say what are maybe some takeaways, something that's maybe 1 or 2 things that stood out from you that you learned from today, or if there's a particular question that you still are not clear about, an area, so that we can cover that on day 2. And thank you again so much, and thank you. We apologize for the little glitches, but we should be smooth sailing for day 2. Thank you.
Thank you very much. So if I could ask our HUD partners to remain on the call while everyone signs out, just so that we can finalize the preparation right in for day 2. Okay, and then of course our partner at PBS, this concludes our recording. Thank you.